behalf of Kiko UK Ltd and Pianoforte Holdings.
Mr. Rob.
My lords, I am John Robb and I appear for the Appellant Kiko UK Ltd. My learned friend Ms. Cheng appears for the Respondent, Pianoforte Holdings S.p.A. I plan to finish my submissions by 12:45 p.m, if that's convenient, giving Ms. Cheng until 4 o'clock and retaining 15 minutes or so at the end for reply submissions.
I'm not saying no to that. I should say we have read the papers with some care. So if it's possible for everyone to go faster than that, we won't be sorry.
I will certainly try to do so. Please do hurry me along if that's helpful. Your Lordships will have seen that the clause at the centre of the appeal needs to be taken from two different places in the bundles. First, there's page 135 of the core bundle, which contains the actual written text of clause 3.2 of the deed of guarantee and indemnity, which we've been referring to as the parent company guarantee of PCG. Second, there is page 77 of the core bundle, which contains paragraph 18 of the judgment below, where His Honour Judge Cadwalader set out the additional words that he held ought to be inserted into the clause to give it grammatical sense, and neither side has appealed against that finding. If it is convenient, I can hand up a single double-sided page of paper which has both of those pages on it, in case that avoids some flicking back and forth during
By all
the
means, thank you very much.
The facts underlying the appeal are summarised at paragraph 4 of Kiko's appeal skeleton, which is core bundle tab 4, page 27. And those facts are in turn based on paragraphs 7 to 8 of the judgment. There are just 2 points from those paragraphs of the judgment that I'd like to pick out, if I may. And that's CB tab 8, page 74. The first is paragraph 7 of the judgment, the passage which reads from the second line. And on the 28th of June 2024, Jamino's liquidator gave notice disclaiming Jamino's interest in the lease. And it's the final sentence I allow. As between Kiko, Pianoforte and Pontegadia, it was deemed to continue to subsist, however, pursuant to section 1784B of the Insolvency Act 1986. That final sentence was common ground at trial. My learned friend has not applied for permission to cross appeal against it, so I submit that not only is the sentence obviously right as a matter of law, but it's not open to my learned friend to argue to the contrary. And that knocks out Pianoforte's response to ground 2 of the appeal. Second, paragraph 8 says, on or about the 26th of July 2024, Pontegadia required Kiko to enter into a new lease agreement. The parties agreed that it was entitled to do so. That was under clause 4 of the HEA. It's that liability to enter into a new lease which gave rise to the part of Kiko's claim which is the subject of this appeal. And 2 short points about that. Firstly, a liability arose on the 26th of July 2024, so during the period when there was still a notional deemed lease in existence. Second, the liability arose as a result of the service of a notice by the landlord, Pontegadia. It may not ultimately matter, but I just note that it was Pontegadia's service of the notice rather than Jamino's liquidator's disclaimer of the lease per se, which was the immediate cause of Kiko's liability to enter into a new lease. As your Lordships are aware, there are 5 grounds of appeal, and those are all by tab 3. I'd like to start briefly with ground 4, commercial common sense, since commercial common sense is obviously a fact to take into account on the various other questions of construction that arise on the other grounds, and then I will take the remaining grounds in turn. So I begin with appeal ground 4. It's addressed by Kiko's skeleton, core bundle tab 4, pages 33, at paragraphs 21 to 23 and 28.3. And I can summarise Kiko's case here in 3 propositions. Proposition 1. This is a case where Kiko, as the assigner of a lease, was obliged to enter into an authorised guarantee agreement and took a deed of guarantee and indemnity from the SME's parent company. My submission is that the obvious purpose of Kiko's taking guarantee and indemnity from Jamino's parent was for Kiko to protect itself against the risk of Jamino becoming insolvent. I've cited strong authority at paragraphs 21 to 23 of my skeleton. Perhaps I can just ask your lordships to highlight two passages, both of which I can take from the Hindcastle case, which is in the authorities bundle at tab 6. The case begins at page 77. And the first extract is at page 97 of the authorities bundle, which is page 90b of the case report. And 90b of the case report, so towards the top of the page, the first indented paragraph. Lord Nichols quoted Chief Justice Gibbs in the 1817 case of Inglis and McDougall. The very object of taking sureties is to provide against the insolvency of the principal. And the second quotation I ask your lordships to highlight is at the very bottom of page 100 of the authorities bundle. This is page 93H of the case report. It's the final sentence of the page. In the present context, it is essential to have in mind that the fundamental purpose of an ordinary guarantee of another's debt is that the risk of the principal debtor's insolvency shall fall on the guarantor and not the creditor. My second proposition is that this being a situation where Kiko has given the guarantee under the AGA and is taking what is in effect a counter guarantee under the PCG, Kiko's commercial purpose of protecting itself against the risks of Jamino's insolvency is not achieved unless the PCG is construed in a way that indemnifies Kiko from the consequences of any of the forms of liability that it might acquire under the AGA following Jamino's insolvency. And that includes potential liability to take a new lease under clause 4 of the AGA, which, as your lordships know, is a core bundle, tab 17, page 152. My submission is that it is just as absurd, to quote Lord Nichols's language in Hindcastle, quoted paragraph 23 of the skeleton, it is just as absurd that Kiko should be left without indemnity for its clause 4 AGA liability to enter into a new lease, as it would be if Kiko were left without indemnity for its liability to make good Jamino's defaulted rent payments. My third proposition is that the PCG itself discloses an intention that Kiko should not be adversely affected by disclaimer of the lease by Jamino. Could I ask your lordships to turn up tab 14 of the bundle, which is the PCG, and at page 135, clause 4.1. The liability of the assignee's guarantor, so that's Pianoforte, shall not be reduced, discharged, or otherwise adversely affected by, and a long list of things, including 4.1.8, the disclaimer of the liability of the assignee under the lease. My submission is that is as clear as possible an indication of the parties' objectively construed intention that, as between Kiko and Pianoforte, the risks relating to a disclaimer of the lease by Jamino's liquidator should rest on Pianoforte and not on Kiko.
Well, if there was a seriously foreseeable eventuality, the insolvency of the assignee, which would render the tenant liable to take a fresh new lease on the same terms, then the whole commercial arrangement would be disastrous. And that's exactly why the provisions are structured as they are.
My lord, I think I'm being slow.
I'm agreeing with you.
I hope so. Yes, that's why it's structured the way it is.
I'm not sure if it's contended otherwise. I mean, it seems to me that the judge's construction means that something's gone very wrong with the commercial arrangement.
I'm grateful. Your lordships have my submission on the underground form. That's my submission. And I add, but it's icing on the cake, that the result is all the more unreasonable when it's Pianoforte as the sole member of Jamino, which put Jamino into creditors' voluntary liquidation. And I've made a submission of paragraph 4.2 of the grounds of appeal, which is CB3, page 25. But there is serious risk of abuse here. The parent company putting its subsidiary into liquidation in the expectation that it will thereby be able to escape its guarantee liability.
We're getting out of jail free, aren't we?
Precisely right. Now, the judge did not address in his judgment the submissions on commercial common sense in these terms, which were made by Kiko below. There's nothing in the judgment to indicate that the judge had regard to the commercial consequences of his interpretation of clause 3.2 of the PCG. Nor is there any attempt in my learned friend's skeleton argument to justify a construction of clause 3.2 of the PCG that would leave Kiko without recourse against Pianoforte for a paragraph 4 AGA liability to enter into a new lease. At tab 5, page 54 of the core bond, paragraph 39 of my learned friend's skeleton. Bottom of the paragraph. The only explanation that I can see for how a clause on the judge's construction would appear is it may be the case that the drafters of the PCG had considered that the respondent's liability would cease as from the date of disclaimer of the lease, and therefore aligned the PCG with this position accordingly. Well, that would be to impute a mistake of law to the drafters of the PCG, because as between Kiko, Pianoforte, and Pontegadia, the respondent's liability did not cease with the date of disclaimer of the lease, and that's the clear effect of Hindcastle, Shaw of Dolman, and indeed of the summary judgment application judgment of His Honour Judge Pelling in this very case. So my submission is that the reasonable person, that is a person who has all the background knowledge which would reasonably have been available to the parties in the situation in which they were at the time of the contract, does not make a mistake of law. So really this paragraph of Pianoforte's skeleton proves my point. If clause 3.2 really does have the law given to it by the judge, then it is so unreasonable that it can only have been the product of a mistake. So I submit that I rely on the principle stated by Mr. Joseph Bobblewell in paragraph 8 of the Ocean Neptune. So in the bundles, we've refrained from putting in rainy sky and everything else. But if there are two possible constructions, the court is entitled to prefer the construction that is consistent with business common sense and to reject the other. I'll move on to grounds 1 and 2. These are both about the construction of the expression at the end of clause 3.2. Any failure by the assignee to pay any of the rents reserved by the lease, etc., or to observe or perform any of the tenant covenants of the lease. If I may, I will use the expression failure to perform as a shorthand to refer to that language that I've just read from the end of clause 3.2. And now I've addressed what I say were Jamino's failures to perform at paragraphs 9 to 10, and paragraphs 28 to 29 of Kiko's appeal skeleton. But it's possible to be a bit more analytical and to distinguish between three different relevant senses in which there was, we say, a failure to perform by Jamino. First, Jamino failed to pay rent during the period up to the liquidator's disclaimer of the lease on the 28th of June 2024. And that is coming back. Second, after the 28th of June 2024, the lease had in fact terminated, but, to quote paragraph 7 of the judgment, as between Kiko, Pianoforte and Pontegadia, it was deemed to continue to subsist pursuant to section 1784B of the Insolvency Act 1986. So it follows that there was a continuing deemed failure to perform by Jamino over the period between 28th of June 2024 and the 14th of November 2024. That is the subject of ground 2 of the appeal, and I'll come back to it.
Do you also rely upon clause 4.1.8 in that regard?
Yes.
I wonder if you really need the Insolvency Act if we're looking at the contract.
My lord, yes. To be very clear, the effect of the judge's construction is that the liability which Pianoforte would have had but for the clause 3.2 on the judge's construction has been adversely affected, has been reduced. And that is what clause 4.1.8 says is not to handle. And so yes, I submit the 4.1.
That's what it's there, that's what it's there for, isn't it?
That's what it's there for. Exactly. And His Honour Judge Pelling came to a comparable view in the context of the AGA when submission had been made that Kiko's liability had finished as a result of the disclaimer. And there was a similar provision there that said Kiko's liability shall not be affected by disclaimer. And His Honour Judge Pelling said, well, there's the answer. So yes. So continuing deemed failure up to 14th of November 2024. And then the third relevant failure on Kiko's case, and this is ground 1 of the appeal, is what I'd submit is the most straightforward and obvious failure that happened when Jamino's liquidator disclaimed the lease. It is simply that before the disclaimer, Jamino owed all of the various tenant obligations that would fall to be performed over the remaining term of the lease. Jamino didn't perform these obligations. The disclaimer announced that it wouldn't be performing them, and it had the effect that it couldn't perform them because the lease had been terminated. So there was, on any view, non-performance of the various obligations which had existed immediately before the notice of disclaimer took effect. And my submission under ground 1 is that that non-performance is properly described as a failure to perform those obligations. I'll demonstrate that by reference to 2 things. First, ordinary language usage of the expression fail to perform. And second, usage of the expression failure to perform in the context of a contract that is terminated for repudiatory breach, which I submit as a close analogy for reasons I'll come to. So on analysis, what took place on the 28th of June 2024, the date of disclaimer, was a prospective but certain failure by Jamino to perform the obligations that would counterfactually have owed over the remaining term of the lease if the lease had not been terminated by disclosure.
So I just wonder how much you need to go into the proposition that disclaiming a lease is not performing it.
Indeed, my lord. I will show you, your lordship, one thing that I didn't put in my skeleton. I don't know if an additional authority reached you yesterday.
This is
Lost.
Austrian left.
Yes, and it's page 350 of that report. I can hand up copies of Alpha. So I rely on the passage at page 350. Sorry. Page 350 C to E, where Lord Diplock in this passage is just talking about what happens when repudiatory breach of contract is accepted. And starting at D, end of the line, the primary obligations of the party in default to perform any of the promises made by him and remaining unperformed likewise come to an end, as does his right to continue to perform them. But for his primary obligations, there is substituted by operation of law a secondary obligation to pay to the other party a sum of money to compensate him for the loss he has sustained as a result of the failure to perform the primary obligations. And all I rely on here is that usage of failure to perform the primary obligations, even in a scenario where the contract is terminated, the primary obligations no longer exist. It is nevertheless natural language usage to refer to there having been a failure to perform. I will not. I think I can.
Well, yes, but this is not apposite to disclaimer situations.
Well, let me just say what I say in the similarities. And I do take the point that I'm possibly over-egging the pudding and going into complexity that is unnecessary, because the straightforward and obvious thing is not where there has been disclosure. There has been
simply what does failure to perform mean in the context of the guarantee and indemnity?
Exactly, given a commercial construction.
Given the commercial construction, and does disclaiming a lease, the liabilities under which have been guaranteed constitute not performing the lease.
Yes.
I'm not sure that looking into primary and secondary obligations in a sort of photo production satirical sense really gets us anywhere.
No, my lord. What I'm doing is I'm analysing and answering and explaining what I say is the error in paragraph 51 of the judgment. That's called by the tab 8, pages 85 to 86. Final sentence of page 85. Nor do I see that a disclaimer is or involves a failure to perform the ongoing liabilities when its effect is to determine the ongoing liabilities. And my submission is that that is a false binary. Whether there has been a failure, well, there has been a failure if one does not perform a continuing subsisting obligation, and there has been a failure to perform if one does not perform the obligation because the contract has been terminated, at least where the termination is for a reason that in some broad sense can be said to be the party's fault.
But it's certainly right that the whole purpose for liquidator disclaiming is so that they are not thereafter failing to perform the lease. They disclaim it so that they are no longer under that obligation because it's an onerous obligation. But that's not the question that we're looking at.
They no longer have the primary obligation, obviously.
But they no longer have a secondary obligation.
I know, and what happens is that there is a cause of action against the estate under 1786. And so the similarities with repudiation are evident. One, in both cases, there is a termination of the lease or contract. Two, both confer on the counterparty a right to compensation for the loss of those primary obligations. And of course, in the repudiatory breach scenario, it's secondary obligations to pay damages. And in the disclaimer scenario, it's the statutory right to compensation against the insolvency estate. And third, the fact that there is a right to compensation in both cases reflects an intuition that in both cases termination is the fault of the repudiation or disclaiming party. But I think that is getting into complexity that I do not need. I will.
But again, forgive me, I'm asking you too many questions, but in terms of construing, interpreting the guarantee and indemnity, do we not again there come back to 4.1.8? Because it tells us that the respondent can't rely upon disclaimer.
Exactly. And I suppose I have three analyses for why there's been relevant failure. Maybe that your lordship is focusing on the ground 2 analysis, which is there's been a deemed failure, and then 4.1.8 tells you that what has happened must be construed as a failure. I'm making the further point, and it may be wholly unnecessary, that simply as a matter of ordinary language, and indeed as a matter of analysis of one of the most exact and precise judges of the 20th century, it makes sense to describe what has happened as a failure to perform, and the fact that the lease was terminated makes that expression no less apposite. So that's my submission under ground 1.
I mean, with all these contractual questions, you look at the language in the context.
Yes.
And I'm not sure necessarily that looking at what Lord Diplock says tells you very much about this particular context. We have to look at what these words might be thought to mean to a reasonable person in the context of this contractual setup.
Yes. Absolutely, my lord. What I would say is, if necessary, the passage from Lord Diplock shows one that what I am submitting is at least an available construction. But I would also prefer to say it's the natural and the correct intention. Ground 2 is that there was a deemed continuing failure. And in a sense, all I need to do is to point you, as I have done, to paragraph 7 of the judgment. But in short, we don't accept the premise that there is only a failure to perform where there is an actual breach of a subsisting primary obligation. But even if that premise were right, then the judge should nevertheless have held that this requirement was satisfied, because as between Kiko and Pianoforte, it is deemed to have been satisfied. So that's the argument on ground 2.
At the end of the day, isn't in the context of a situation where the tenant remains liable for non-performance by the assignee, what performance means is anything which renders the tenant liable to pay.
Yes, my lord. Yes.
Sorry, non-performance is anything that renders the tenant liable to pay the landlord.
And then, by tenant, do you mean my client?
Yes.
Yes.
Anything, any conduct on the part of the assignee which results in, rather than the assignee having discharged the liability under the lease, your client becomes liable on its guarantee as tenant. That is a failure to perform.
Precisely.
And that's how you would construe this.
Precisely.
That's all we want.
And that is the whole purpose.
That's all you need.
Yes, my lord. And your lordship used the language of non-performance, but the words are failure to perform, and the point stands there. I'll deal with anything else under ground 2 and reply if necessary. Ground 3 was focusing on the arising from language in clause 3.2. That's developed in Kiko's skeleton at paragraphs 32 to 35. Now, given, obviously, if the court is with me so far as to there having been a failure to perform, then arising from doesn't present any particular difficulty. If it had been necessary, if it is necessary to do so, then my submission is that arising from can be construed in 2 senses. First, a causal sense, second, a contextual sense. And looking at a causal sense, we start with Kiko came under a liability on the 26th of July 2024. The immediate cause of that is that Pontegario, the landlord, had served notice on Kiko. And the cause of that, in my submission, is Jamino's failure to perform. It was no longer performing the lease. I should show the court the 2 relevant findings on this point by the judge. First is Cobb tab 8, page 85, paragraph 50. The obligation to take the lease arose under the AGA from the disclaimer of the lease. And then it's the second finding. I'll show you the court both. It is at paragraph 48. Second sentence, a thing may arise from more than one other thing. That's obviously right. Next sentence, I reject the argument raised by Pianoforte that the disclaimer was necessarily the sole trigger for the requirement to take the new lease. So that is what was said in the judgment. If the court is accept the disclaimer entailed a failure to perform by Jamino, and the judge's finding of paragraph 50 amounts to a finding that Kiko's obligation to take the new lease arose from Jamino's failure to perform. But if it is necessary to do so, I've made the submission of paragraph 17.3 of Kiko's skeleton that what one should be looking at is what caused Pontegario to serve the notice that it did. And in fact, I would submit the correct analysis is that the disclaimer by Jamino's liquidator gave Pontegario the opportunity to exercise a right under clause 4 of the AGA. But the cause of Ponte Guardia serving the notice is that Jamino had ceased performing the lease. That, anyway, it deals with a causal sense of failing to perform. And if it were necessary, I would say that arising from implies something wider than direct linear causation. And it is satisfied by a situation where event 1, to say that event 2 is caused by event 1, can apply where event 1 is an ongoing state of affairs, and event 2 is something that takes place within that narrative context. So that gives effect to the metaphor inherent in the language of arising from, something coming up out of something else. And in that contextual sense, there is a situation where Jamino has been failing to perform this lease since 2021, and he's continuing to fail to perform the lease, and then actually the disclaimer happens once completely put it out of its power to perform the lease. And on any common sense view, Ponte Guardia's service of the notice arises from that state of affairs in a narrative sense. Ground 5. My final ground is that actually clause 3.2 of the AGA makes it clearer still, because it provides in terms that Kiko's indemnity obligation includes, for the avoidance of doubt, any costs and liabilities of the assignor arising under any authorised guarantee agreement. To come back to Lord Justice Phillips' point, that is precisely the sort of language that one would expect to find in an instrument like this, in a situation like this, because that is the whole purpose, objectively construed purpose of what is going on. So I dealt with this in written submissions, a paragraph 37 to 45, that's CB4, pages 38 to 39. Essentially making the point, paragraph 44 of my slides, that the judge's construction of these words cannot be correct, because on his construction, what these words are saying is that costs arising under any authorised guarantee agreement are costs, that liabilities arising under any authorised guarantee agreement are liabilities. And that is an inane thing for anybody to have said. And that cannot be what the parties have intended here. Now, the actual text of clause 3.2 of the PCG is at page 135 of the core bundle. But I'm conscious that doesn't show the text that the judges and both parties accepted ought to be interpolated. If it assists, I have one further handout, but I don't know if my main friend objects to me has it up. What I've done here is to set out 4 different permutations of the clause. The first version is the text as it actually appears in clause 3.2. The second version adds the interpolated words from all costs and liabilities, but I've stripped out the bracketed words. The third version puts back in the bracketed words, so that third version is the text that actually falls to be interpreted. And the question at the heart of this 5th ground appeal is, well, what's the difference between version 2, which parties didn't provide for, and version 3, which they did provide for? And then version 4 includes the bracketed words but puts them in a different place, and we can ignore that for the moment ultimately my submission is going to be that there's no difference in version 3 and version 4. My argument under ground 5 can be summarised in 5 propositions. The first proposition is that, if possible, the words in brackets, including for the avoidance of doubt, any costs and liabilities of the assignor arising under any authorised guarantee agreement, should be construed in a way that gives them some effect or potential effect. So I'm relying on the presumption against surplusage. The second proposition, this is the point I've already summarised, made paragraph 44 of Kiko's Appeals Guide, is that the judge's construction is not a plausible construction, because it would be pointless. That nobody could ever have thought that you needed to specify that liabilities arising under an AGA are liabilities. The third proposition is that instead the natural way of reading the words, including for the avoidance of doubt, any costs and liabilities that the assignor arising under any authorised guarantee agreement, is that any costs and liabilities of Kiko arising under the AGA are going to be included within the scope of the indemnity. That's the natural way to read a sentence of the form, you are to do X, including for the avoidance of doubt, Y. And I submit that that's correct. That reading is correct as a matter of grammar too. I'll come back to that. My fourth proposition is really with Justice Phillips' point that Kiko's construction is what one would expect the parties to have agreed in this situation. And my fifth proposition is that if the court were against me in relation to what a strict grammatical construction of these words would look like, then the correct conclusion would have to be that the parties got the grammar wrong. So there were just 2 points that I wanted to develop there. One was very briefly, says, so obviously I rely on the presumption against surplusage. We've put Lewison in the bundle, in the authority bundle at tab 20. And wrote trouble using 724. But what I wanted to address in anticipation is that, of course, there are dicta to the effect that the presumption against surplusage is not in all cases a strong presumption. And I submit that in this case, it should, in fact, it is a strong presumption for 3 reasons. First, clause 3.2 is a relatively short clause, and the insertion looks like something that's intended to add something. And this is not like the cases referred to under paragraph 7.29 of Lewison, which talks about the torrential style of drafting of certain forms of commercial contract. Second, this is a case where the presumption of surplusage points in the same direction as commercial common sense, so it's not somebody trying to invite the court to adopt a deeply uncommercial interpretation based on a technicality. And third, the dicta casting doubt on the weight of the presumption against surplus, which say in effect that we shouldn't be too surprised when we come across some redundant language in a commercial contract. And of course that's true. But my submission is that typically where one finds redundancy, it's either because there's a sort of linguistic overkill referred to in Lewison at 729 and 730. Parties are using a number of phrases expressing more or less the same idea. Or because somebody has inserted a provision into a charter party or a lease, forgetting that there's already a provision elsewhere in a long commercial document which achieves the same thing. And here, the judge's interpretation doesn't just involve that sort of everyday accidental redundancy. Instead, it involves attributing to the parties the absurd intention of specifying that liability arising under an AGA is a liability. My submission is that tautological redundancy of that sort, whose pointlessness is immediately apparent on its face, is not common. And so it should be presumed that that's not what the parties intended. Finally, under ground 5, I just wanted to develop my submission that Kiko's interpretation of the language is grammatically correct. And my submission there is, if one looks at version 3, the words arising from any failure by the assignee either to pay any of the rents reserved by the lease or to observe and perform any of the tenant covenants of the lease. They are qualifying words, but the words they qualify are all costs and liabilities in the first line. So, in a sense, what the parties haven't written here is to indemnify and keep indemnified the assignee from all costs and liabilities arising from any failure, etc. Brackets, including for the avoidance of doubt, any costs and liabilities of the assignee arising under any authorised guarantee agreement, arising from any failure by the assignee, etc. So the words qualify the words from all costs and liabilities, which appear immediately before the brackets. They do not qualify the words inside the brackets. And that is correct as a matter of grammar, even where the words are positioned. And at any rate, the grammatical construction I've just contended for is an available grammatical construction.
Well, again, just stepping back and looking at what is happening here. My understanding, do correct me if I'm wrong, is that as a tenant who is assigning their interest in the lease, they remain liable on the lease to the landlord.
Because of the AGA.
Well, they would anyway, wouldn't they?
I think not since the Landlord and Tenant Covenants Act.
There was a change in the law, as you say. It used to be that the original tenant was liable forever through the term, and then the law was changed, but there is provision for what I think colloquially called ARGAs, so that it is possible for the original tenant to retain liability.
And what we have here is that this guarantee and indemnity is executed on the 2nd of September.
Now, it's not an accurate dating, and the judge made a finding that the two documents were executed at around the same time.
They were actually at the same time.
Yeah, and I think
I see.
it's that paragraphs 3 and 4 of the judgment, that's page 73 of the bundle. First word of paragraph 4, at about the same time, Kiko, Jamino, Pianoforte entered into a guarantee and indemnity agreement. So yes, this is all part and parcel of the same commercial arrangement.
Yes.
I have two more points briefly to cover. One, to say what it is we're asking for if the appeal succeeds, and second, to respond to a small handful of points in the Home Defence skeleton that I haven't already addressed. So, as to the former, if the appeal succeeds, then Kiko will ask the court to make an order as formulated at paragraph 47 of Kiko's skeleton argument. That's CV 4, page 39. That is very...
Sorry, let me just find that.
Yes, of course. It's tab 4, page 39 of the bundle.
So, paragraph 47.
Yes. So the judge, having found against us on this part of our claim, did go on to assess our losses in the event that his decision was overturned on appeal. Now there is one wrinkle, which is that the third of these elements, we can pick up paragraph 75 of the judgment, which is tab page 91. In fact, starts at paragraph 73. So one of the 4 heads that he did assess was what he referred to as future new lease losses. So losses that Kiko was going to suffer under the new lease, but which had not, in the event, occurred by the time of trial, and made a prospective assessment. Now, essentially, we've discovered in the preparation for this trial that one of the elements we put forward at trial, the loss that we were going to suffer if all the alternatives was wrong. And we have voluntarily conceded in correspondence that we would strip that out from the number. So the result is that the figure which I have given at paragraph 48.3 of my skeleton, that was a figure of 849,000. That would reduce down to 726,338.35.
Sorry, 726,338.
38.35.
Sorry, I haven't got that quite right. It's 72638.
726,338.35.
And that's a different figure from the 723,338.49 in paragraph 49 of your skeleton.
It is indeed, and I can't immediately explain why that should be the case. But it may be that by the time
I mean, so just to be clear, when you say in paragraph 47 you want judgment in those amounts, it's not actually quite accurate, at any rate as regards paragraph 75 of the judgment.
exactly.
But were you to succeed in the appeal, then you could, between you, supply a corrected figure in relation to the paragraph 75 element.
I'm grateful. Kiko will also ask, if the appeal succeeds, ask the Court of Appeal to vary the judge's costs on them, and I'll address that at paragraph.
Just before you do, looking at paragraph 49 of your skeleton, you adjust the 849 to 723, whether or not that should be 723, possibly 726. But you're also at that stage suggesting that 35,580 should be compared with 15,000.
Yes, my lord. After that was at a point where we considered that there might be a question as to should there be any fresh assessment. And the answer is that nobody has put in fresh evidence, nobody has sought for there to be a fresh and going back to the authorities, no, there shouldn't be a fresh assessment.
So
therefore
we can forget about 35,580.
Exactly.
Yeah.
And so at paragraphs 50 to 51 of Kiko's appeal skeleton, I've said what I submit. The costs order below, and effectively it should be varied from Pianoforte paying Kiko costs of £300,000 to instead Pianoforte paying Kiko costs of £383,619.09. And since none of the judge's judgment order has been satisfied, the number should be 383,619.09.
Now, maybe we can just leave this aspect to worry about at the judgment stage if the judgment is ultimately in your favour.
Yes, my lord.
I know Ms. Cheng has some comments. A premise is that you're entitled to costs on the indemnity basis because it's equivalent to damages, as I understand it.
Yes, my
And
lord.
that's not in dispute, or is it in dispute?
It was it was a conclusion that the judge came to below in his assessment of the costs. So my primary submission would be that the Court of Appeal should go the same way because that's what the trial judge did.
And that particular element is not the subject of challenge by either party on this appeal. Yeah.
I think just 4 short points from my own friend's skeleton. The first, so this is Core Bundle, tab 5, pages 52 to 53. paragraph 37 of my learned friend's sketch of appellants. That's page 53 of the book. Now, here, my learned friend seeks to rely on clause 2.2 of the PCG. I haven't shown you all of this, but it's tab 14 of the core bundle, page 134. It says, provisions of this agreement shall take effect on the date of the assignment and shall, pausing there, indicating the linkage between the two, and shall continue until the end of the term of the lease, however it may end, and during any statutory continuation of it, or until the assignor is fully released from the liability under the Authorised Guarantee Agreement, if earlier. And a learned friend submits that, this is her final sentence for paragraph 37, the lease came to an end on the 28th of June 2024 when it was disclaimed by Jamino's liquidator, and the PCG similarly came to an end on the same date, i.e. by 28th of June 2024, by virtue of clause 2.2 of that agreement. And I submit that is wrong. It ignores the established point that as between Kiko and Pianoforte, the lease was deemed to continue beyond the 28th of June 2024 and until the 14th of November 2024. And indeed, that was conceded by Pianoforte alone. Perhaps I can show you, Lordships, tab 13 of the bundle, page 120. So this is from Pianoforte's defence alone. Page 120, paragraph 3b of Pianoforte's defence. As between Pianoforte and Kiko, the last day on which Jamino was to be treated as bound by the terms and covenants of the original lease was the 14th of November 2024. And the same one can see at paragraphs 4a and 4c. So it's not open to my learned friend to seek to submit that the PCG came to an end on the 28th of June 2024 as a result of clause 2.2 of the PCG. And if necessary, I just note that Pianoforte had made a similar submission on the summary judgment application, which took place before his Honour Judge Appellant. And the submission there had been that there was a similarly worded clause in the AGA. Kiko's liability under the AGA came to an end on the 28th of June 2024 with the disclaimer. And that was rejected by His Honour Judge Appellant, KC. That's Authorities Bundle tab 12, paragraph 15, paragraphs 14 and 15. So, perhaps I could just ask the Lordship to read those two paragraphs.
Sorry, paragraphs 14 and 15.
14 and 15, that's page 165 of the Authorities Manual. So there his honour Judge Padding was construing a different clause in the ARGA, but precisely the same point. The second of the 3 points I wanted to make about Lennon Friends Skeleton is at paragraph 42. That's core bundle, tab 5, page 55. So paragraph 42, Lennon Friends says, further or alternatively, the respondent cannot be subject to any further liability under clause 3.2 of the PCG after the 14th of November 2024. Now, just to be clear as to the nature of Kiko's claim, and this was explained by the judge at paragraph 43 of the judgment, core bundle tab 8, page 84. In failing to prevent Kiko from coming under that obligation, there's an obligation to enter into new lease, Pianoforte breached its indemnity obligations, and Kiko is entitled to damages to compensate for that. So the answer is there was a breach by Pianoforte of its indemnity obligation on the 26th of July 2024. That breach occurred before 14th of November 2024. And my client, if the appeal succeeds, is entitled to damages compensated for and losses resulting from that breach. My third and final point is about the same paragraph 42 of my learning friend's skeleton, and the second half of that paragraph. I'll read it. So this is about 8 lines up. The respondent would venture to go a step further and argue that as at the 26th of July 2024, when Pontegardio requested the appellant to enter into the new lease, it, Pontegardio, was already by its conduct demonstrating an inconsistency with there being a continuing liability on any other person to perform any tenant covenants in, under, or arising out of the lease. As Lord Nichols made clear in Hindcastle, a landlord cannot have possession of the property and at the same time claim rent from the property from others. Now that is a submission called appeal rejected in Bash and Steckel, 2001 Landlord and Tenant Report 1, which is at tab 7 of the authorities bundle. And in fact, head note paragraph 1, head note paragraph 9. But we can take it from paragraph 25 of Lord Justice Chadwick's judgment, page 103 of the authorities bundle. So, a submission relying on the same passage from Hindcastle, I think that the landlord's act in serving the notice, I should show you what notice was served. I don't immediately have it, it was a notice requiring tenant to enter into a new lease. Submitted that the landlord's act in serving the notice on February 11th, 1998 was an act of taking possession, alternatively an act which demonstrated that he no longer intended to rely on the continuing liability of the executors to perform the tenant's covenants of the lease, so as to prevent the landlord thereafter from relying on the guarantor's liability to perform the tenant's covenants. In my view, that submission is misconceived. The service of a notice requiring the executors to take a lease cannot, of itself, be treated as an act of taking possession by the landlord. The effect of the notice, if valid, is to bring into existence a contract under which the executors are obliged to take a grant. When they take a grant, the landlord will, under the terms of that grant, be required to deliver vacant possession. But he will not be required to deliver vacant possession until the grant is taken. By serving the notice, the landlord asserts that he is ready, willing, and able to give vacant possession at the time when the grant is taken. But that, of course, this landlord was in a position to do, in the circumstances that the estate formerly existing under the lease had been So those are my submissions and that's consistent.
Thank you very much, Mr. Law. Ms. Chair.
My lords, I would submit in the first instance that this is a relatively simple matter for the courts, which is to deal with the interpretation and construal of clause 3.2, which my learned friend has already kindly taken the court through in quite some detail, including the various different interpretations, the 4 different interpretations, which are set out on the 1 page of A4. What this court needs to determine is whether there has been a failure by the assignee, so that is Jamino, and whether as a result of such failure to either pay rent or to perform any of the tenant covenants. And I do understand from my learned friend submissions that the Kiko's primary submission is that there was a failure to pay rents, but alternatively they are relying on 3.2.2, which is the failure to perform any of the tenant covenants. But firstly, it must be determined whether there is such a failure. Secondly, the causation element, whether, and I understand that this goes to ground 3 of the appeal, which is whether as a result of such failure, Kiko then had to enter into this new lease, and therefore whether any costs and expenses arising as a result should be borne by Pianoforte rather than by Kiko. Now, I intend to address the various grounds, the 5 grounds, as well as the points made by my learned friend under 3 different headings. Firstly, the ordinary, or the interpretation of the word failure and what this means. Secondly, the nature of disclaimer. So, of course, as His Honour Judge Cadwallader also observed, we're not here to ascertain what the nature of disclaimer is, but the importance of disclaimer is for us to understand and to assist in the construal of clause 3.2. And lastly, my 3rd heading is the intentions of the parties. And so this takes us not only to looking at clause 3.2, but also the remainder of that particular documents, as well as the license and AGA. Which are the relevant documents. And so, and the first thing that I would also like to observe at the outset is, although my learned friend has spent some time looking at clause 3.2 and the different ways in which this can be interpreted, it was clearly set out in my learned friend's skeleton arguments. This was at paragraph 7, that Kiko agrees with the interpolation and the conclusion reached by the judge below. And we say that that conclusion reached was correct. And therefore we also say that, we say that in summary, the judge in the court below was correct in his determinations, and the appeal should be dismissed in its entirety. But looking first at this word failure and what it means, my learned friend has provided various authorities in which various courts have looked at the word failure and what this means in the particular facts and circumstances of those cases. As this court has observed, the word should be looked at in its ordinary usage and in its particular facts and circumstances. And I would submit that what is important is the construal of that particular word in this clause. And so it's of little assistance to look at what has been done in other circumstances. I have set out the principles of interpretation at paragraphs 26 to 30 of my skeleton arguments, including authorities. Those are not disputed between the parties, and so I don't intend to go through those in detail. But essentially, the words should be construed, and I do agree with how it has been set out in ground 1 and ground 4, but in its ordinary language and also common sense. And what should be noted is that the specific use of the word failure was chosen by the legal teams of the parties. Kiko was at all times represented by Brown Jacobson, which is a reputable law firm. It's evident that the legal team would have given clear thoughts as to the choice of the word failure as opposed to any other term, such as non-performance. And this was observed by His Honour Judge Cadwallader in the courts below. And we say this is important, and looking at this in conjunction with the license for assignment, in particular paragraph 3, and this can be found at page 151 of the authorities bundle.
Of the core.
Sorry, yes, apologies, core bundle. I'm looking at the words 4 lines down in that paragraph, my lord, which stipulates that Jamino shall pay rents only until such time as it is released by law from all liability under the lease. I'm emphasising the word liability there. Now, unless...
Sorry, I wasn't keeping up. So we're in clause 3.
Of the licence for assignment.
So the assignee covenants that until such time as it's released by law from all liability.
Under the
you
lease.
Pay the rent.
Yes. And so the word liability there presupposes that there must be a legal obligation for Jamino to pay rents. Otherwise, why clause 3.2 would only come into play, that there must be a legal obligation on Jamino to pay rents. And it's difficult to see why it would be required to do so, or indeed to perform any of its tenant covenants, if there is no such legal obligation for it to do so.
Now, this is an obligation that Jamino is undertaking to the landlord. Clause 3.
Yes, this was entered into between Jamino, Kiko, no, not with the landlord, with, yes, with Pontegadia, yes.
Because at the stage at which the lease is being assigned by Kiko to Jamino, the landlord understandably wants a direct covenant from the incoming assignee.
Yes.
Yeah. But that doesn't tell you all that much about what the outgoing original lessee will want by way of protection.
Yes, but this simply sheds some lights on what we say, because we're still trying to understand why the use of the word, why failure was used rather than any other term, such as non-performance, because what Kiko's position is that there doesn't need to be, as I understand it, as my client understands it, what Kiko's position is that it doesn't need to be a legal obligation on Jamino to have to pay rents simply by not paying such rents, even if there was no legal obligation for it to do so. This would result in it failing to pay rents or failing to perform its tenant covenants, and therefore this would lead Pianoforte to be in breach of clause 3.2, and this is what we take issue with. So this is my first heading under the definition or the construal of the word failure. And what assists us to understand this further is the effects of disclaimer. So in Hindcastle, the courts emphasize that a lease either exists or it does not. And what disclaimer does is it operates to determine the interest of the tenants in the disclaimed property as from the date of the disclaimer, which was on the 28th of June 2024.
We're moving on to your second heading now.
Yes. And therefore, as of that date, the 28th of June 2024, when the lease was disclaimed by Jamino's liquidators, this clearly brought the lease to an end. And as regards any rights, obligations, or interests that Jamino had in the lease, this was also all brought to an end. And therefore, we say that as regards ground 2 of Kiko's appeal, we say it's incorrect, Kiko's submissions here, that as between Kiko and Pianoforte, Jamino was in breach of a subsisting rents obligation in the subsisting lease in respect of the whole period up to the 14th of November 2024.
Don't we have to interpret 3.2 in the whole of in the context of the whole agreement? And that means we have to interpret it with clause 4.1.8.
Yes, but what 4.1.8 also seeks to do is 4.1.8 goes to the assignee's guarantor's liability. The assignee is Jamino, and the assignee's guarantor is Pianoforte. And therefore, what 4.1.8 goes to is Pianoforte's liability. And we need to look at these in two parts. Firstly, what disclaimer does as regards Jamino, and what disclaimer does as regards Pianoforte and everybody else, including other third parties.
If you're right, 4.1.8 would be meaningless, wouldn't it? Because there would be nothing to guarantee after disclaimer.
So this takes me to the nature of disclaimer and the purpose of disclaimer, because we've already looked at the fact that what disclaimer serves to do is to terminate the lease, as well as all rights, obligations, and interests of Jamino itself. As regards the other parties, what Section 178(4)(b) serves to do is to ensure that there is a statutory fiction so that the lease is deemed to continue in existence. And this is as regards all other persons other than Jamino. However, what is important here is because this is simply a statutory fiction, at Hindcastle, in the case of Hindcastle, the court stressed, and I'll take the court to the relevant passage, which is at tab 6 of the bundle, and at page 100. H. It's there should be a sidebar. It's a little bit above the sidebar at H as well. But the court stressed here that the law has gone to great strengths to see that guarantors are not called upon to discharge burdens different from those that they originally undertook. And this is because although the statute takes effect as a deeming provision, which is a commonplace statutory technique, the determination such that the determination of the lease is not permitted to affect the rights or liabilities of other persons other than Jamino. However, and if I may now take the court to another authority.
Sorry, just before you do, so
Yes.
what do you say you get out of what Lord Nichols says at 93?
What Lord Nichols here emphasizes is that, so this would go to the third point of the intentions of the parties, which is that it's important to look at what the intentions of the parties were when entering into the agreement to ensure that the liabilities of the guarantors are not, do not deviate from what were intended by the parties at the outset.
I follow that. I mean, he then goes on to explain that the guarantor's liabilities can continue even when the principal debtors don't.
Yes, that is correct. So it very much depends on what the intentions of the parties were when entering into the contracts. But going back to the fact that Section 178 is essentially a statutory fiction and a deeming provision to ensure that even if Jamino is off the hook, other parties may still be on the hook. And this was an authority that was relied upon by Kiko. But there is a paragraph here which I think is important. It's the case of ex parte Walton at tab 2 of the authorities bundle. At page 16, and it's where the sidebar is, beginning at the top of the sidebar with the words when a statute. So quoting from this decision, when a statute enacts that something shall be deemed to have been done, which in fact and truth was not done, the court is entitled and bound to ascertain for what purposes and between what persons the statutory fiction is to be resorted to. And we say that this is very important. It was in fact referred to also by the courts in a later case in Harding and Priest, which is also included in the bundle at tab 3. And we say this is
And
important.
just before you leave
Yes.
that page, you find at the top of that page takes you the bit that Lord Nichols, I think, quotes later. Could it ever have been intended that the bankruptcy of the lessee was to release the surety? And arguably, it can be said, well, could it ever have been intended that the disclaimer of the lease should release you?
Yes. And so this takes us to my next point, which is what is the rationale of all of this, which we say is to preserve any existing proprietary rights and to protect the position of the landlord. And we say this is what all of the case authorities go to show.
But plainly, the document we're concerned with is not to protect the position of the landlord. It's to protect the position of the original tenant.
That is, if the parties had been minded to ensure that that was the position, then especially given that they were represented by legal teams, they could have drafted the language in such a manner. However, we say that the language of the documents does not show that the parties had that intention in mind, and that it was simply to protect the position of Ponte Guardia, who was the ultimate landlord in this matter.
I mean, as to the particular document we're concerned with, which is the guarantee given by your client,
Yes.
plainly that the purpose of that document is only to protect Kiko. I mean, the landlord is not a party to it.
Yes, I see that, my lord.
And just going back to my lord's point one moment, 4.1, clause point 4.1 of that document. So it says the liability of the guarantor shall not be reduced or affected by disclaimer of the liability of the assignee. Now, it is necessarily the case, is it, on your construction of this document, that the disclaimer will bring the guarantor's liability to an end?
We say that that doesn't need to be the case on the
Well, is there
section, but
any
in this case, yes.
Is there any circumstance in which disclaimer will not bring the guarantor's liability to an end on your case?
No.
So can you give any meaning to 4.1.8?
We say that 4.1.8 also needs to be read, although reading 4.1.8 in isolate, it's important to consider the words in 4.1.8, but we say that it's also important to consider this in the context of the entire document as a whole, including in conjunction with clause 3.2, 2.2, as well as in conjunction with the license and AGA, especially considering that the documents were entered into at around the same time. So we say that although looking at 4.1.8, I do understand the court's concern that this would appear to suggest that it was, especially given that the document was not entered into with Ponte Guardia. I understand the court's concern that there appears, this document would appear to suggest that it was to protect Kiko's position, but looking at this document in conjunction with the license and AGA, we say, especially looking at paragraph 4 of AGA, we say that all of this, what all of these documents do is in fact, what they do is to serve to protect the ultimate landlord's position. And this is what all the case authorities also go to show, that ultimately the landlord Ponte Guardia was concerned to ensure that it had the protection of either the original tenant, such that if Jamino was no longer able to pay its rents, then it would be able to go after Kiko.
So that on your case, the parties enter these documents, the very next day, your client puts Jamino into liquidation, they disclaim the lease. Kiko is absolutely without any remedy because it didn't protect himself against that position.
Yes, well, we say Kiko could have drafted the language in such a way so as to protect its own position.
Isn't that exactly what they did by putting in that the liability of your client shall not be reduced, discharged, or otherwise adversely affected by the disclaimer of the liability of the assignee under the lease? Which seems to me to be exactly the same effect as the statutory fiction, isn't it? Isn't that an indication that the statutory fiction is intended to apply here?
Well, that may be the case, my lord. But going back to what the language of clause 3.2, which is whether there was a failure by the assignee, and this is where it's also important for us to look at paragraph 4 of AGA, because what paragraph 4 of AGA does is it provides for the situation when Pontegardia, the ultimate landlord, could have asked Kiko to enter into a new lease. If it was simply the case that Jamino had failed to pay its rents, and if this was a breach of its tenant covenants, then as the ultimate landlord, what Pontegardia could have done was to bring a claim and sue Jamino for breach of its tenant covenants. It did not do so. Instead, what it did was it complied, it followed the procedure set up in paragraph 4, which was that if the lease is disclaimed, then the landlord may, within 3 months and after any such disclaimer, require the tenant to accept a new lease of the demised premises. This is what it did. And therefore, we say that actually, even though there are various provisions, and although 4.1.8 in isolation would suggest would suggest the importance and would suggest that Kiko was very much protecting its position by also providing for paragraph 4 of AGA here, clearly Kiko was well aware that if there was a disclaimer, then there would be a possibility, and there would be a very strong possibility, that what Pontegardia would be doing would not be bringing a claim against Jamino for failure to pay rents, but rather requesting Kiko to enter into a new lease, which is what it in fact did so.
Isn't that exactly why it would be commercially bizarre if your analysis is right? Because it would mean that Kiko had disastrously failed to protect its position, and your client had a complete let-out for its guarantee liability in relation to its subsidiary. It just puts it into liquidation, it's scot-free.
Well, we say this was a commercial arrangement between the parties.
It doesn't make any sense, does it? It doesn't make any sense at all. Why would Kiko agree to be on the hook for the rest of this lease until its end, with no right of recourse against your client? What's the point of having the guarantee?
On hindsight, it's always easy for parties to say that they entered into a bargain which they wouldn't have on hindsight with all the information that they had afterwards.
Can you give us any commercial rationale as to why this would have been a sensible commercial arrangement for the purpose of construing it against the commercial context?
Well, my lord, what we do know from this matter is after Kiko entered into this new lease in November 2024, it says that it has made all reasonable attempts to mitigate its losses by seeking to enter into a new sublease and trying to find a new subtenant. And it's understood that Kiko has not been successful in doing so, which shows that perhaps it may have been, I can't say, we don't have the evidence as to what had happened at the time when this sublease was entered into with Jamino, but given the difficulties that Kiko has had subsequently in finding a tenant to take over the premises, this suggests that there may have been a possibility that even at the time when the when the lease was entered into with Jamino, that Kiko may have had some difficulties, and I'm speculating here, my lord, but as to that question of commercial arrangements, Kiko would have had its own reasons for
You mean that they
entering.
were so glad to get any tenant that they were prepared to agree, take the risk that Jamino might go bust?
If
Is that what you're submitting?
yes,
Just trying to understand. Yes.
yes. My lords, but going back to the rationale and the purpose of a disclaimer, as I submitted, this is simply to protect and preserve the existing proprietary rights already in existence as at the date of the disclaimer. And although we say Kiko could have done more to protect its own interests, what we say is ultimately what Section 178 does is to serve to offer protection to the landlord, Ponte Guardia, which is done in this case if Kiko enters into the new lease. And even if there is such a fiction, we say that the fiction comes to an end as at the date when a new lease was entered into. We know that that took place on the 15th of November 2024, and therefore in any event that statutory fiction would have been deemed to have terminated when the new lease was entered into.
What is particularly extraordinary about the suggestion here is that Kiko assigned to a subsidiary of a foreign company, and on your case has taken the risk that the foreign company would be able to put the English company into liquidation and would have no remedy against the parent company, which seems to me to make completely no sense at all out of the whole commercial arrangement. If your client had become insolvent, then obviously that's the risk one takes dealing with any corporate entity. But the extraordinary thing here is that on your case, your client is still in existence and apparently good for the money, but that by virtue of the structure adopted, Kiko hasn't got any remedy against them because they allowed the English company to go into liquidation.
That may be the case, my lord, but that is how Clause 3.2 is structured. And what Clause 3.2 does is it simply asks the question whether there has been a failure to pay rent or to observe any of the tenant covenants. And we say the relevant date of that is at the dates, or Kiko says the relevant date is the is in July, the 26th of July 2024, when Kiko was requested by Ponte Guardia to enter into this new lease. And we say as at that date, the lease had terminated as far as Jamino was concerned.
I think you say it's the date of disclaimer. It's when
Yes. So the lease had terminated in June 2024. Yes. But therefore, this means that looking at the relevant dates, I understand from Kiko's position, the relevant date is July 2024 when it was requested to enter into this new lease. So whether there was a breach of 3.2 as at that particular date, and as at that particular date, if the lease had already terminated. So in essence, our very simple point is how should clause 3.2 be construed? And it's simply whether there was a failure by Jamino to pay rents or to observe any of its tenant covenants. And the relevant date for determining this, we say even taking Kiko's position at its highest, being the 26th of July 2024, when Kiko was requested to enter into this new lease by Ponte Guardia, as at that point the lease had terminated, and therefore as at that point there cannot have been any obligation or any liability on Jamino to perform any further tenant covenants because the lease had simply terminated. And therefore, that being the case, there can have been no failure by Jamino to perform any of those two things set out in clause 3.2. And therefore, there can be no breach by Pianoforte, given that that is a secondary liability, which only follows if there has been a failure by Jamino to do those things. My lords, I will swiftly go on to deal with grounds 3 and 5. So the causation elements. Firstly, we say that my learned friend makes a point that arising from is wider than a linear causation and therefore encompasses this particular situation. Is my submissions that if a mere narrative connection is used, then this renders the words devoid of all meaning, since we can always go further back in time or encompass or take in further circumstances. But again, looking at these words in the ordinary usage, clearly this must mean whether there is this causation element, whether it is the case that any failure by Jamino had resulted in Kiko having to enter into this new lease. Even asking the question which Kiko asks, which is, why did Ponte Guardia decide to exercise its clause 4A right to require Kiko to enter into a new lease? Again, I've already taken your lordships to paragraph 4 of AGA, but what this clearly shows is if it was simply the fact that Jamino had failed to pay its rent under the lease or failed to perform any of its tenant covenants, what the landlord could have done was to have brought a claim and sued Jamino for breach of its tenant covenants. It did not do so, and instead it decided to follow the steps set out in paragraph 4 and request Kiko to enter into this new lease. And therefore we say that the facts and the events which caused Kiko to enter into the new lease was a disclaimer by Jamino's liquidators rather than a failure by it to pay its rents. Ground 5, I will deal with very, very swiftly here. It's simply that Kiko had already confirmed that it was in agreement with the conclusion and the interpolation that was reached by the court below. What the court was seeking to do was to clarify clause 3.2. We say that the conclusions reached by the judge was correct here. I don't intend to deal with the issue of the actual losses. There are a few points that I wish to make in relation to costs. I don't know whether...
Do you mean costs in the event that the appeal is successful?
Yes, well, there are two issues in relation to costs in Kiko submissions. Firstly, I understand there's an appeal in relation to the costs that were awarded by the judge in the court below. And secondly, that Kiko is seeking its costs in the event that it is successful. But dealing...
I suspect it does make sense to hear you on some of this, but just to be clear, those are not grounds of appeal, they're things that would flow from success in the appeal.
Yes.
Yes, I follow.
Would it be helpful for me to make my submissions at this point, or...?
I mean, what will ultimately happen, since we're not proposing to give judgment today, is that judgment will be reserved and you'll be sent the draft in due course. And at that stage, we welcome submissions on any consequential matters. And obviously, should the appeal be successful, we'd welcome submissions on costs, consequences of the appeal succeeding. I suspect that means that we don't particularly need you to say anything at this stage, but are there points that you think it would be helpful to bring out now rather than leave them to be dealt with in writing should the appeal succeed?
No, not particularly. It was only if it would be of assistance to the courts.
It doesn't look as though my brethren think it would be.
I'm grateful.
So is there anything else you need to say at this stage?
I don't believe so, unless there's anything further I can do to assist.
Thank you very much.
Thank you.
Mr. Robb, any reply?
Two very short points of reply, if I may. The first is just to ensure that I've not created any confusion when I said that I agreed with the judge's interpolation of text. So that is agreeing with paragraphs 16 to 18 of the judgment, it is agreeing with paragraph 18 of the judgment.
Yes. This is your version, your formulation 2 in your sheet.
Exactly. So clearly, by agreeing with that interpretation, I am not thereby agreeing that the judge correctly interpreted the words in parentheses.
It's your option 3, isn't it?
So
You're quite right. It's option 3 that we get to.
option 3 is what I say are the words that we interpret. Exactly. Exactly. But the submission was made that somehow I'd thrown away ground 5 of the appeal by agreement. Clearly I have. The second point is responding to my learned friend's submission that when clause 3.2 refers to failure, it must refer to an actual and not merely a deemed breach of subsisting lease. And my submission is simply that's contrary to Hindcastle and to the authorities that have followed it. And particularly helpful in this context is Shaw and Dolman, which is at tab 10 of the authority file. I'll just show you your lordship's 3 passages in there.
And this is a case post the change in the law on the liability of original tenants.
Exactly. So the so like in our case, it's a claim against a guarantee, against a guarantor. This is a claim by the landlord against the assignor who has given a guarantee to the landlord in an AGA. And one can see the terms of that. AGA, paragraph 19 on page 136. Clause 3 of the AGA provided the guarantor guarantees to the landlord that the assignee will pay the rents reserved by, perform and observe the tenant's covenants in the lease, and the guarantor will pay and make good to the landlord on demand any losses, damages, costs and expenses suffered or incurred by the landlord if the assignee fails to do so. And I'd highlight paragraph 20 as well, because the real argument in Shaw and Dolman was about the construction of clause 3.2 of the AGA in that case. Under clause 3.2, the guarantee remained in force for the liability period, which is defined in clause 1.4 as the period during which the assignee is bound by the tenant covenants of the lease. So there's a question, did that mean the period during which, as between the assignee and the landlord, the assignee is actually bound? Or did it mean the period during which, as between the assignee and the assignor, the assignee is notionally to be treated as being bound as a result of the Hindcastle fictional lease? And what each of the three members of the Court of Appeal said is that the construction of each clause of the AGA had to proceed on the footing that there was in existence the notional continuing lease. So to take it from paragraph 55, which is Lord Justice Elias. This is recording the submission of counsel to the landlord. And I read about the fourth sentence. It is of course open to the parties to limit the guarantor's liability so as to terminate on disclaimer, but very clear words are necessary to achieve that objective. And that's because of all the considerations of commerciality that we've been talking about. Start with paragraph 56. Again, it's a submission that was accepted. When construing the guarantee agreement, the words used must be read in the context of common law and statutory background, with the consequences that the liabilities of the assignee are deemed to continue, even though they do not continue in fact. The guarantee agreement must therefore be read on that premise. And in paragraph 60, Lord Justice Elias accepts that submission. I have no hesitation in preferring the argument of Mr. Fancourt. The effect of Hindcastle is that the lease is deemed to continue, and the obligations of the assignee are deemed to remain in place. This fiction permeates the whole of the agreement. The assignee must be treated as if he were bound by the tenant's covenants, even though he is not in fact so bound. He remains bound for the purposes of determining the rights and obligations arising out of the relationship between the landlord and the guarantor. So, of course, here we are interpreting an instrument in the nature of a counter guarantee given by the parent company of the assignee to the guarantor, but the same statutory fiction applies, and the same effect can be seen in Lord Justice Mummery's judgment at paragraph 38 and Lord Justice Stanley Burton's judgment at 47, but I don't think I need to go. That was all I wished to say by way of reply, unless there's anything else I can assist with.
Very much. Ms. Cheng, I think you're entitled to respond on Shaw and Dolman, that not having been cited by Mr. Rob first time round. So if there's anything you want to add on Shaw and Dolman, please do so.
No, just a very simple point, my lord, which is that what Shaw and Dolman does, along with all the other authorities which have been relied upon, is to protect the position of the landlord rather than the original tenants. And therefore, again, going back to the point that I emphasised, Pontegardia in this instance has been protected. And therefore, if Kiko did wish to ensure that it would be protected, it could have done so, but has not done so in this case.
Thank you very much. Well, as I indicated a moment ago, we're not going to give judgment here and now. Thank you both very much for your submissions. You will be supplied with the judgment in draft for you to comment on our typing and our English, but that won't, of course, be an opportunity to re-argue the case. And again, as I mentioned a moment ago, we'd be grateful if at that stage you would seek to agree in order dealing with consequential matters. If there are points on which you can't agree, can we please have brief written submissions, and we would expect to settle the points in the order that we make. I ought also, although I'm sure you're very well aware of this, to remind you of the importance that attached to the embargo. It is still quite regularly, I think, being broken. That's something that the court takes seriously. If you do think of anybody else who needs to see the judgment in draft, you need to come back to us to get approval. You can't just send it to them. I'm sure you knew all that already, but I say it again just to be on the safe side. But thank you both very much for your submissions.
Thank you.
All right, David.
very good time.